Hello everyone, welcome to MAYANK LAWHOLIC. In this video, we will discuss the previous year's question paper of Delhi Judicial Service of 2019. So let's get started from the question number 1. Question of title to an immovable property in a suit under section 6 of the Specific Relief Act is relevant, irrelevant, both depending upon the facts of the case and none of these. Correct answer is option second, that is irrelevant, because section 6 of Specific Relief Act 1963 talks about the suit by person dispossessed of immovable property. Now let us see the question number 2. An injunction can be granted to prevent the breach of a contract the performance of which would not specifically enforced. Option 2, to prevent a continuing breach in which the plaintiff has acquiesced. Option 3, to restrain any person from applying to a legislative body. And option 4, none of these. Correct answer is none of these. Question number 3. Mandatory injunction is governed by, correct answer is section 39 of the Specific Relief Act. Section 39 of the Specific Relief Act talks about the mandatory injunctions. Mandatory injunction is when to prevent the breach of an obligation, it is necessary to compel the performance of certain acts which the court is capable of enforcing. The court may in its discretion grant an injunction to prevent the breach complained of and also to compel performance of the requisite acts. Now let us see the question number 4. A suit of declaration without seeking consequential relief is barred by, correct answer is section 34 of the Specific Relief Act. Section 34 of Specific Relief Act talks about the discretion of court as to declaration of status or right. Question number 5. Mandatory injunction is the nature of restitution, prohibition, both first and second, none of these. Correct answer is third, both restitution and prohibition. Question number 6. Contract for sale of a Maruti Ciaz car can be specifically enforced, cannot be specifically enforced, only damages can be claimed, both second and third. Correct answer is option second, cannot be specifically enforced. Question number 7. Contracts are not specifically enforceable are enumerated in, correct answer is section 14 of the Specific Relief Act. Section 14 of the Specific Relief Act explains contracts not specifically enforceable. Now let us see the question number 8. Which contract cannot be specifically enforced? A contract which is in its nature determinable, a contract which is so dependent on the personal qualification of the parties that the court cannot enforce a specific performance of its material terms. Option 3, both 1 and 2. And option 4, a contract of sale of immovable property. Here the correct answer is option 3, that is both first and second. Question number 9. He is a lazy person and wants a touch of the spur. The italicized phrase in the above sentence means, correct answer is wants rousing up. Question number 10. The faculty for myth innate in the human race. Faculty in the above sentence most nearly means, correct answer is capacity. These seats are dash for ladies. The High Court said dash the sentence. Winter has now set dash. The blanks in the above sentence can be most appropriately filled in the following order. Here the correct answer will be apart, aside, in. These seats are set apart for ladies. High Court set aside the sentence. Winter has now set in. Now let us see the question number 12. Pick the list of correctly spelled words. Correct answer is option first, experience, experience. This is correct. Receive, receive, receive. Acquiesce, acquiesce, acquiesce. So option first is the correct answer. Question number 13. Pick a sentence that is grammatically incorrect. Options are, my requirement is that everyone be punctual. The flock of geese have 30 words. Either the table or the chair needs to be fixed. The Union of Carpenters advocates for better pay. Here the correct answer is option second, because it has been asked the incorrect option. So this second is the flock of geese have 30 words. This is the incorrect statement. That's why it is correct in the question. Now let us see the question number 14. Hardly we entered dash it started pouring. Correct answer is hardly had we entered when it started pouring. Scarcely did I feel asleep dash my phone rang. Correct answer is when. Question number 16. No sooner had I sat down dash the bell rang. The blank can be filled most appropriately by using then, when and lest. Correct answer is then. She has dash sense. There is dash money in my purse. We do not sell dash then 1 kilogram of tea. Correct answer is option third, little some less. We do not sell less than 1 kilogram of tea. She has little sense. There is some money in my purse. Now let us see the question number 18. He said Where is the station? The above sentence can be expressed in indirect speech as he inquired where the station was. Question number 19. Geeta and dash went to Delhi. Between you and dash he is a liar. Let you and dash work together. Here correct answer is option third. I, me, I. Geeta and I went to Delhi. Between you and me he is a liar. Let you and I work together. I shall meet her without dash delay. Delhi is dash from Mumbai then Surat. He had nothing dash to say. You need to go dash into the matter. Correct answer is option second. Further, farther, further, further. I shall meet her without further delay. Delhi is farther from Mumbai than Surat. He had nothing further to say. You need not go further into the matter. Question number 21. This is a dash edition of the book. This is the dash news. I could not hear the dash part of his speech. Here the correct answer is option third. Later, latest, latter. This is a later edition of the book. This is the latest news. I could not hear the latter part of his speech. Now question number 22nd. The word dilettant means. Correct answer is amateur. Question number 23. He is so weak dash. The above sentence can be completed by most appropriately by adding. Here the correct answer is option 4, that he cannot walk. Question number 24. The thieves dash the police. In his speech he dashed to a great person. He dashed me into lending him my car. The blanks in the above sentences can be filled most appropriately in the following order. Correct answer is option second. Eluded, alluded and deluded. The thieves eluded the police. In his speech he alluded to a great person. He deluded me into lending him my car. Question number 25. The judge acceded dash my request. The master dispensed dash the service of a servant. Nobody is free dash faults. Here the correct answer is option 4th. To, with, whom, from. The judge acceded to my request. The master dispensed with the services of his servant. Nobody is free from fault. Question number 26. Impecunious means. Correct answer is option 3rd. Without money. Question number 27. We don't care a fig for her. Write some unknown correspondent with a pretty little handwriting and a pink seal. Note. She is fade and inspired. And add some more kind remarks in this strain, which I should never have repeated at all, but they are in the truth prodigiously complimentary to the young lady whom they concern. The tone of the above passage can best be described as ironical, elegiac, skeptical, loving. Here the tone is ironical. Question number 28. To have a chip on one's shoulder means to be arrogant. Question number 29. In which of the following cases a partnership does not exist? Options: lender of money receiving profits, servants or agents receiving profits, widow or child of a deceased partner receiving profits, seller of goodwill receiving profits. Correct answer is option 4th, that is all these. Partnership doesn't exist. Now let us see the question number 30. A partner cannot contract himself out of which of the following duties? Duty of utmost good faith, that is uberrimate fidei, duty to carry on business to a greatest common advantage, duty to render true accounts and full information, duty to indemnify for fraud, duty to indemnify for willful neglect, duty to properly use the firm's property. Here the correct options are option 3rd, that is 1st, 2nd, 3rd and 4th. Question number 31. A notice to one partner operates as a notice to the whole firm. However, the notice must have been given to a partner who habitually acts in the business of the firm. Notice to a dormant or sleeping partner would also suffice. Notice to a partner who commits a fraud on the firm will not be a notice to the firm. Both 1st and 3rd are correct. Here the correct option is 4th option, that is both 1st and 3rd options are correct. The vice president is elected on the basis of adult franchise by the people of India, by an electoral college consisting of the all members of Rajya Sabha by secret ballot, by an electoral college of all the members of both the houses of parliament, by electoral college consisting of all the members of both the houses of parliament in accordance with the system of proportional representation by means of single transferable vote and by secret ballot. Here the correct answer is option 4th. Question number 33. There is no fundamental right of a person arrested not to be detained in custody without being informed, as soon as may be the grounds for such arrest or for period beyond that of 24 hours of such arrest, excluding the time necessary for journey from one place to arrest to court without the authority of magistrate, in case of one who for the time being is an enemy alien, in case of one who is arrested or detained under any law provided for preventive detentions. Both 1st and 2nd and option 4 none of the above. Here correct answer is option third, that is both first and second. In case of one or who for the time being as an animal alien, in case of one who is arrested or detained under any law providing for preventive detention. Both the options are correct. An amendment to the Constitution of India make change in the provision relating to establishment and constitution of the Supreme Court requires before giving assent by the President. Options are to be passed by a majority of not less than 2/3 of the members present and voting in each house, ratification by resolution to that effect by legislatures of not less than 1/2 of the states, both first and second, none of these. Here the correct answer is option third, both first and second. That is to be passed by a majority of not less than 2/3 of the members present and voting in each house, and option second, ratification by resolution to that effect by legislature of not less than 1/2 of the states. Question number 35. An ordinance promulgated by the President of India in exercise of his legislative power shall cease to operate or to have effect or be of same force an act of Parliament at the expiration of the 6 months from the reassembly of Parliament, upon passing of resolution by one House Parliament endorsing the disapproval thereof, express the resolution of other House upon it being withdrawn by the President. On option 4, all these. Here the correct answer is option 4, that is all of these. Question number 36. If only a part of a single consideration for one or more object is unlawful, the correct shall be valid to the extent the same are lawful, void to the extent the same are unlawful, void as a whole, and valid as a whole. Here the correct answer is option third, that is void as a whole. Question number 37. A letter of acceptance sent by post is lost in transit. There is no concluded contract as the letter of acceptance is put in the course of transmission. There is no concluded contract as the acceptance has not come to the knowledge of the proposer. There is no concluded contract as the acceptance has not been committed to the proposer. None of these. Here the correct answer is option first, that is there is a concluded contract as to the letter of acceptance is put in the course of transmission. Question number 38. A and B go into a shop. B says to the shopkeeper, let A have the goods. I will see that you are paid. This is a contract of guarantee. Question number 39. An agreement in restraint of trade is void to the extent of such restraint. Question number 40. If the compensation to be paid on breach of contract is the genuine pre-estimate of the prospective damages, it is known as liquidated damages. Question number 41. If the time of performance of contract is of essence and the promisor fails to perform his part by the specified time, the contract is voidable at the option of the promise. Question number 42. An agency is terminated by the principal revoking the authority of the agent, agent renouncing the business of agency, death of the principal or agent, and option 4, all of these. Correct answer is all these. Question number 43. If a person fails to comply with the terms of notice for appearance under section 41A clause 1 of the Code of Criminal Procedure and is unwilling to identify himself, the police officer may, subject to such orders as may have been passed by a competent court in this behalf, arrest him for the offence mentioned in the notice, shall arrest him for the offence mentioned in the notice, may not arrest him for the offence mentioned in the notice, may without an order from a magistrate and without a warrant arrest him. Here the correct answer is option first, may, subject to such orders as may have been passed by a competent court in this behalf, arrest him for the offence mentioned in the notice. Now let us see the question number 44. The memorandum of arrest to be prepared by every police officer while making an arrest shall be attested by at least 2 witnesses, one of which shall be a member of the family arrested, attested by at least 2 witnesses, one of which is a member of family of person arrested, and the other gazetted officer living in the locality where the arrest is made, and option third, attested by at least 1 witnesses who is a member of the family of the person arrested or respectable member of the locality where the arrest is made and shall be countersigned the person arrested as far as may be possible in the circumstances in which arrest is made, arrested by at least 1 witness. Here the correct answer is option third, that is attested by at least 1 witnesses who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made and shall be countersigned by the person arrested. This is the correct answer. When any offence is committed in the presence of a magistrate within his local jurisdiction, he may only direct a police officer posted in a police station within his local jurisdiction to arrest the offender, order only a gazetted police officer to arrest the offender, himself arrest or order any person to the offender, and option 4, none of the above. Here the correct answer is option third, that is himself arrest or order any person to arrest the offender. Now let us see the question number 46. If any court has reason to believe that any person against whom a warrant has been issued by its absconded so that such warrant cannot be executed, such court may publish a written proclamation requiring him to appear at a specified place and at specified time, not less than dash from the date of publishing of such proclamation. Options are 15 days, 30 days, 45 days and 65 days. Correct answer is 30 days. Compensation can be awarded to the victim of a penal offence under dash of the Code of Criminal Procedure. Here the correct answer is option 4, that is both second and third, that is section 357 and section 357A. An order for a monthly allowance for the maintenance or interim maintenance and expenses of proceeding under section 125 of CRPC shall be payable from the date of application for the maintenance or interim maintenance and expenses of proceedings from the date of the order, or if so ordered from the date of the application for maintenance or interim maintenance and expenses of proceedings from any date as the magistrate may deem fit and proper. Question number 48, correct answer is option 3rd, that is from the date of the order, or if so ordered from the date of the application for maintenance or interim maintenance and expenses of proceeding. This is the correct answer. Question number 49. An order for alteration in the allowances for the maintenance or interim maintenance can be made by a magistrate under section 127 of the CRPC on proof of a change in the circumstances of the instance of. Options are any person receiving under section 125 a monthly allowance for the maintenance of interim maintenance. Option second, any person ordered section 125 to pay a monthly allowance for the maintenance or interim maintenance. And option third, relative of any person ordered under section 125 to pay a monthly allowance for the maintenance or interim maintenance. And option 4, both first and second. Question number 49, option 4 is correct, that is both first and second. Section 125 is section 125 CRPC is related to order for maintenance of wives, children and parents, and section 127 of CRPC talks about the alteration in allowance. Now let us see the question 50. Which of the following statement is false in the context of section 155 of the CRPC regarding investigation in non-cognizable cases? Options are no police officer shall investigate a non-cognizable case without the order of a magistrate having power to try such case and commit the case for trial. Option second, any police officer receiving such order may exercise the same powers in respect of the investigation, including the power to arrest without warrant, as an officer in charge of a police station may exercise in a cognizable case. Option third, when a case relates to 2 or more offences to which at least one is cognizable, the case shall be deemed to be a cognizable case, notwithstanding that the other offences are non-cognizable. Option 4, upon the receipt of information of the commission of a non-cognizable offence, the officer in charge of a police station shall enter the substance of the information in a book in such form as the state government may prescribe in this behalf. Correct option is option second. Any police officer receiving such order may exercise the same powers in respect of the investigation, including the power to arrest without warrant, as an officer in charge of a police station may exercise in a cognizable case. Section 155 of CRPC in detail discussed information as to non-cognizable cases and investigation of such cases. A magistrate may take cognizance under section 190 of the Code of Criminal Procedure of any offence. Options are upon receiving a complaint of facts which constitute such offence, or upon his own knowledge that such offence has been committed, upon a police report of such facts, upon information received from any person other than a police officer, then such offence has been committed, and all these. Here the correct answer is option 4, all these. Section 90 of CRPC deals with the cognizance of offences by magistrates. Question number 52. In case an application for bail is filed by the accused who is alleged to have committed an offence under section 376AB of IPC, in such case it is first mandatory to give a notice of such bail application before granting bail to the public prosecutor within a period of 15 days from the date of receipt of notice of such application. Second, mandatory to give a notice of such bail application before granting bail to the public prosecutor within a period of 7 days from the date of the receipt of notice of such application. Third, not mandatory to give the notice to the public prosecutor if the complainant or informant is represented through a private counsel. Fourth, not mandatory to give notice to the public prosecutor if the court considers it is not practicable to give such notice. Here the correct answer is option first, that is mandatory to give notice of such bail application before granting bail to the public prosecutor within a period of 15 days from the date of receipt of notice of such application. Question number 53. Any court may alter or add to any change before examination of an accused under section 313 of the CRPC, after examination of an accused under section 313 of the Code of CRPC, but before examination of defense witnesses. Third, before examination of any prosecution witnesses. And fourth, at any time before the judgment is pronounced. Here the correct answer is option 4, that is at any time before the judgment is pronounced. Question number 54. When in any warrant case instituted otherwise than on a police report, the accused appears or is brought to before a magistrate, the magistrate shall satisfy himself that he has complied with the provisions of section 207 of CRPC, postpone issue of process against the accused if he is residing at a place beyond the area in which exercises his jurisdiction, Option third, either inquire into the case himself or direct an investigation to be made by a police officer for the purpose of deciding whether or not there is sufficient sound for proceeding. And option fourth, shall proceed to hear the prosecution and take all such evidence as may be. Correct answer is option fourth. Shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution. Now let us see the question number 55. When in a summon case the accused appears or is brought before the magistrate, the prosecutor shall open his case by describing the charge brought against the accused and stating by that evidence he proposes to prove the guilt of the accused. Second, the magistrate shall frame in writing a change against the accused if, upon considering a police report and a document sent with it, making such examination as the magistrate thinks necessary, the magistrate is of the opinion that there is ground for presuming that the accused has committed an offence. Option third, the particulars of the offence of which he is accused and shall be stated to him, and he shall be asked whether he pleads guilty or has any defence to make, but it shall not be necessary to frame a formal charge. This is the correct answer. Question number 56. Section 293 of the CRPC regards reports of government scientific experts applies to the Director of Central or State Forensic Science Laboratory, the Deputy Director of a Central or State Forensic Science Laboratory, the Assistant Director of a Central or State Forensic Science Laboratory. Option 4, all these. Correct answer is option 4, that is all these. Section 293 CRPC talks about the reports of certain government scientific experts. Question number 57. The authorities of Section 297 of the CRPC before whom affidavits may be sworn to be used before any court under the Code of Criminal Procedure may be sworn or affirmed before by any judge or any judicial or executive magistrate, any commissioner of oaths appointed by High Court or other court of session, any notary appointed under the Notaries Act 1952, and option 4, all of these. Here the correct answer is option 4, that is all of these. Section 297 CRPC talks about the authorities before whom affidavits may be sworn. Question number 58. The Code of Session shall ordinarily hold its sitting as per Section 9 of the Code of Criminal Procedure. At such place or places as the High Court may by notification specify of it any particular case, the Court of Session is of the opinion that it will tend to the general convenience of the parties and the witnesses to hold its sittings at any other place in the Session Division. Option second, at such places or places as the High Court may by notification specify if any particular case, the Court of Session is of the opinion that it will tend to the general convenience of the parties and the witnesses to hold its sitting at any other place in the Session Division. It may, with the consent of the prosecution and the accused, sit at the place of the disposal of the case. And option third, at such place or places as the state government may by notification specify, or if any particular case the Court of Session is of the opinion that it will tend to the general convenience of the parties and the witnesses to hold its sitting at any other place of the Session Division, it may, with the consent of the prosecution and the accused, sit at that place for the disposal of the case. And option 4, if at any particular case the Court of Session is of the opinion that it will tend to the general convenience of the parties and the witnesses to hold its sitting at any other place in the Session Division, it may, with the consent of the public prosecutor, sit that place for the disposal of the case. Here in question number 58, the correct answer is option second. Now let us see the question number 59. The amount of compensation which a magistrate can direct the complainant or informant to pay for an accusation without reasonable cause under section 250 of the CRPC is, correct answer is option third, as he may determine, but not exceeding the amount of fine he is empowered to impose. This is the correct answer. Question number 60. Withdrawal of the complaint in a summon case under section 257 of the Code of CRPC results in acquittal of the accused. This is the correct answer, acquittal of the accused. Section 257 of CRPC talks about the withdrawal of complaint. If a complainant at any time before a final order is passed in any case under this chapter satisfies the magistrate that there are sufficient grounds for permitting him to withdraw his complaint against the accused, or if there be more than one accused against all or any of them, the magistrate may permit him to withdraw the same and shall thereupon acquit the accused against whom the complaint is so withdrawn. Now let us proceed to question number 61. At any metropolitan magistrate may, if he thinks fit, try in a summary way the following offences under section 260 of the Code of Criminal Procedure. Options first, theft under section 379, 380 or 381 of the IPC where the value of the property stolen does not exceed 2000 rupees. Option second, offences under section 454 and 456 of IPC. Option third, receiving or retaining stolen property under section 411 of the IPC where the value of the property does not exceed 2000 rupees. And option 4, all of these. Correct answer is option 4, that is all of these. All the options are the correct answers. Now let us see the question number 62. Section 363 of the CRPC entitles a person accused of an offence or to receive a copy of the judgment free of cost when he is convicted of the offence, he is sentenced to imprisonment. Correct answer is option second, that is he is sentenced to imprisonment. Question number 63. In calculating the fractions of terms of punishment, section 57 of the IPC prescribes that imprisonment for the life shall be reckoned as equivalent to imprisonment for. Correct answer is 20 years. Question number 64. The maximum term of imprisonment which can be imposed by the court for the offence under section 304A of IPC is. Answer is 2 years. Section 304A of IPC talks about the causing death by negligence. That is, whoever causes the death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either description for a term which may extend to 2 years or with fine or with both. Now let us proceed to question number 65. Under section 63 of IPC, where no sum is expressed to which a fine may extend, then the amount of fine to which the offender is liable is prescribed as. Correct answer is option 4, unlimited but directed not to be excessive. Now let us proceed to question number 66. Where an offence is punishable with the imprisonment as well as fine, the terms for which the court can direct the offender to be imprisonment in default of payment of fine shall not exceed 1/4 of the term of the imprisonment which the maximum fixed for the offence. This is the correct answer. Question number 67. In which case did the Supreme Court first hold that the right of a victim to file an appeal under the proviso of section 372 of CRPC is available against orders of acquittal rendered after 13 December 2009, and that for exercising such right no leave to appeal is required to be sought? Here the correct answer is Mallikarjun Kodagali versus State of Karnataka. This is the correct answer. Question number 68. In which case did a 5-judge constitutional bench of the Supreme Court consider the ambit and scope of 319 of the CRPC? The correct answer is Hardeep Singh versus State of Punjab. Question number 69. A instigates B to burn Z's house. B sets fire to the house and at the same time commits theft of property there. In such a case, A would be guilty of abetting burning of the house but not guilty of abetting of theft. Question number 70. The ambit and scope of the offence of sedition under section 124A of the IPC was considered by the 5-judge constitutional bench of the Supreme Court in the case of. Correct answer is Kedarnath Singh versus State of Bihar. Question number 71. A knows Z to be behind a bush. B does not know it. A, intending to cause or knowing it to be likely to cause Z's death, induces B to fire at bush. B fires and kills Z. Correct answer is B may be guilty of no offence but A has committed the offence of culpable homicide. Question number 72. The offence of voyeurism under section 354C of IPC is committed when a man commits the act of physical contact and advances involving unwelcome and explicit sexual overtures. A man makes sexually colored remarks. A man who monitors the use of women of the internet, email or other form of electronic communication. Option 4. A man who watches or captures the image of a woman engaging in a private act in circumstances where she would possibly have the expectation of not being observed either by the perpetrator or by any other person at the behest of the perpetrator or disseminate such image. Here the correct answer is option 4. Question number 73. Hurt as defined in section 319 of the IPC is causing of the following to any person: bodily pain, disease, infirmity, and option 4 all of these. Here the correct answer is all these. Question number 74. Section 377 of IPC regarding unnatural offences was particularly struck down by the Supreme Court in the case of. Correct answer for this is Navtej Singh Johar versus Union of India. Question number 75. Stolen property as per section 410 of IPC includes property, the possession whereof has been transferred by theft, extortion or robbery, property which has been criminally misappropriated, property in respect of which the criminal breach of trust has been committed. Here the correct answer is option 4, that is all of these. Question number 76. The offence of cruelty in section 498A of the IPC punishes subjecting a woman to cruelty by the husband or relative of the husband of a woman. This is the correct answer. Any person known to the woman, this is not the correct answer. Any person, not all these, not. This is not the right option. Option 1 is the correct option, that is the husband or relative of the husband of a woman. Question number 77. Section 34 of IPC regarding a criminal act done by several persons in furtherance of the common intention of all is a separate offence itself, punishable separately. Option 2, only a rule of evidence and does not create substantive offence. This is the correct answer. Now let us see the question number 78. The Supreme Court upheld the constitutional validity of the offence of defamation under section 499 of the IPC in the case of. Here the correct answer is Subramaniam Swamy versus Union of India. Question number 79. A, intending to murder Z by poison, purchases poison and mixes the same with food and delivers it to Z's servants to place it on Z's table. A has committed the offence of attempt to murder. Question number 80. The offence of dowry death under section 304B of IPC is committed where the death of the woman is caused by any burns or bodily injury or occurs otherwise than under the normal circumstances within 7 years of her marriage, and it is shown that soon before her marriage she was subjected to cruelty or harassment by her husband or by a relative of her husband. 10 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband or in connection with any demand for the dowry. Option third, 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband or in connection with any demand of the dowry. Here in question number 80, the correct answer is option third. Section 317 of the IPC punishes the offence of exposure and abandonment of child under 12 years by parent or person having care of it. Section 304 of IPC provides for punishment for the offence of culpable homicide not amounting to murder. A exposes her child with the knowledge that she is thereby likely to cause its death. The child dies in consequence of such exposure. In such circumstances, A may be charged with the convicted of the offence under section 304 of IPC, charged and convicted of the offence under section 317 and 304 of the IPC. Option third, charged and convicted of the offence under section 317 of the IPC, and option 4, charged and convicted of the offences under section 317 and 304 of the IPC but convicted only for the offence of section 304. Here the correct answer will be option second, that is charged with and convicted of the offence under section 317 and 304 of the IPC. Question number 82. A intentionally deceives Z into a belief that A has performed A's part of contract made with Z which he has not performed and thereby dishonestly induces Z to pay money. A has committed the offence of cheating under section 415 of the IPC. Question number 83. Section 471 of the IPC states that whoever fraudulently or dishonestly uses as genuine any document or electronic record which he knows or has reason to believe to be a forged document or electronic record shall be punished in the same manner as if he had forged such document or electronic record. If a person is convicted only for the offence under section 471 of IPC, he will then be imposed punishment for the offence of forgery of the document in addition to having used the same as genuine. Option second, be imposed punishment as prescribed for having committed forgery of the document which used as genuine, both 1 and 2 depending on the facts and circumstances of the case, and option 4, none of these. Question number 83, correct answer is option second, be imposed punishment as prescribed for having committed forgery of the document which he used as genuine. Question number 84, A having insured a ship voluntarily causes the same to be cast away with the intention of causing damage to the underwriters. A has committed the offence of mischief under section 425 of the IPC. Question number 85. Which of the following statement is false with respect to the offence of defamation under section 499 of IPC? It is not defamation to impute anything which is true concerning any person if it be for the public good that the imputation should be made or published. Whether or not it is for the public good is a question of fact. Option second, it is a defamation to express in good faith any opinion whatever respecting the conduct of a public servant in the discharge of his public functions or respecting his character so far as his character appears in that conduct and no further. Option third, it is not defamation to express in a good faith any opinion whatever respecting the conduct of any person touching any public question and respecting his character so far as his character appears in that conduct and no further. And option 4, it is not defamation if a person having any authority either conferred by law or arising out of the lawful contact made with the other to pass in good faith any censure on the conduct of that order in matters to which such lawful authority relates. Here the correct answer will be option second, because in this question it has been asked which of the following statement is false. The second statement is false, which doesn't fall under the section 499 of defamation. A makes an attempt to steal some jewels by breaking open a box and finds after so opening the box that there is no jewel in it. A is option 1, guilty of no offence as there was no jewels to steal. Option second, guilty of the offence of attempting to commit theft of the jewels as he has done the act towards the commission of theft. Option 3, guilty of the offence of committing preparation to commit the offence of theft. And option 4, guilty of theft as it is immaterial whether he could succeed or not stealing some jewels. Correct answer is option second, guilty of the offence of attempting to commit theft of the jewels as he has done act towards the commission of the theft. Question number 87. A begins to unlace the muzzle of a ferocious dog, intending or knowing it too likely that he may thereby cause Z to believe that he is about to cause the dog to attack Z. A has, correct answer is, committed the offence of assault under IPC. Question number 88. The punishment for the offence of forgery of a will is prescribed under section. It is prescribed in section 467 of the IPC. Question number 89. Dishonestly making false claim in court is an offence under section 209 of the IPC. A is cheated with the offence of causing simple hurt. A pleads guilty to the charge before the Metropolitan Magistrate and is accordingly convicted for the said offence and sentenced to imprisonment for 1 year. A can file an appeal. Correct answer is against the extent or legality of the sentence in the Code of Sessions. Question number 91. A is the victim in a gang rape case. At the conclusion of the trial, the accused persons are convicted and sentenced to imprisonment and fine. The court orders the fine amount to be paid to A as compensation. A has also filed an application for the compensation under section 357A of the Code of Criminal Procedure, which is pending consideration before the competent authority. In such a situation, the fine amount cannot be paid to A as compensation since she had already filed an application for the compensation under 357A of CRPC. The state government can pay compensation under section 357A of the CRPC addition to the payment of fine as compensation to A under section 376D of the IPC. This is the correct answer. Option second is the correct answer. Statement of a person recorded by a magistrate under section 164 clause 5A subsection A of the Code of Criminal Procedure can be taken as statement in lieu of the examination in chief where the person is a victim in a case. Here the options are punishable for the offence of kidnapping and the victim is mentally disabled. Option second, punishable for the offence of grievous hurt and the victim is physically disabled. And option third, punishable for the offence of stalking and the victim is temporarily physically disabled. Option third is the right answer. Question number 93. A, knowing that B, C, D, E, F and G are about to commit the offence of dacoity in Kathmandu, Nepal, harbors them in his house in Sitamarhi, Bihar. With the intention of facilitating the commission of such dacoity, A has option first, not committed any offence as the dacoity was yet to take place, not committed any offence that can be tried in India, committed the offence of harboring dacoits, committed an offence which can be tried and punished only in Nepal. Here the correct answer is option third, that is committed the offence of harboring dacoits. Question number 94. A, as an employer deducts his employee's contribution from the wage payable to the employee for credit to the employee's state insurance fund held and administered by the employee's state insurance corporation established under the Employees State Insurance Act 1948. A makes default in payment of such contribution to the said fund violation of the said act. A has option first, not committed any offence. Option second, committed the offence of criminal breach of trust. Option third, committed offence of criminal misappropriation of property. And option four, committed the offence of theft. The correct answer is option second, that is committed the offence of criminal breach of trust. Question number 95. Alibi is governed by. Correct answer is section 11 of the Indian Evidence Act. Communications without prejudice are protected by. Correct answer is section 23 of the Indian Evidence Act. Section 23 of Indian Evidence Act talks about the admission in civil cases when relevant. Question number 97. Under section 27 of the Indian Evidence Act, options are the whole statement is admissible, only the portion of the statement which leads to discovery is admissible, both first and second are admissible, none of the above are admissible. Here the correct answer is option second, that is only the portion of the statement which leads to discovery is admissible. Section 27 of Indian Evidence Act talks about how much of information received from accused may be proved. Question number 98. A dying declaration to be admissible must be made to a magistrate, doctor, police officer, all of these. Correct answer is option 4, that is all of these. Question number 99. The opinion of an expert is relevant under. Options are section 45 of Indian Evidence Act. This is the right option. So the opinion of expert is relevant under section 45 of the Indian Evidence Act. Burden of proof is lightened by. Correct answer is presumption, admission, estoppel. All of these. Question number 101. Legal advisor. Option 1, can disclose a professional communication after the death of his client. Can disclose the professional communication after the relationship with the client has ended. Can disclose the professional communication if made in furtherance of any illegal purpose. Can disclose the professional communication in all the above instances. Correct answer is option third, that is can disclose professional communication if made in furtherance of any illegal purpose. Power of the court to suo motu examine any person at any stage is under section 163 of Indian Evidence Act, section 164 of Indian Evidence Act, section 165 of Indian Evidence Act and section 167 of Indian Evidence Act. Correct answer is option third, that is section 165 of Indian Evidence Act. Section 165 of Indian Evidence Act talks about the judge's power to put questions or order production. Under section 116 of Evidence Act, the tenant is stopped from denying the title of the landlord. Here the correct answer is during the continuance of the tenancy. Section 116 of Indian Evidence Act talks about the estoppel of tenant and of licensee of a person in possession. Question number 104. A fact under section 3 of Indian Evidence Act means and includes. Anything capable of being perceived by the senses, state of things capable of being perceived by the senses, relation of things capable of being perceived by the senses, all of these. Correct answer is option 4, that is all of these. Now let us see the question number 105. An accomplice is a competent witness under Section 118 of the Indian Evidence Act, Section 119 of the Indian Evidence Act, Section 132 of the Indian Evidence Act, and Section 133 of the Indian Evidence Act. Correct answer is option 4, that is Section 133 of the Indian Evidence Act. Section 5 of Limitation Act applies to suits, appeals or application, both 1 and 2, none of these. Correct answer is option 2, that is appeals and applications. Question number 107. The period of limitation for filing a suit for damages for defamation is 1 year. Question number 108. The period of limitation for filing suit of possession under Section 6 of the Specific Relief Act is 6 months. Question number 109. If no period of limitation is provided in the Limitation Act, the proceedings can be instituted within, correct answer is 3 years. Suit for arrears of maintenance can be filed within, correct answer is option 3, that is 3 years. The period of limitation for filing leave to defend in a suit under Order 37 of the CPC is within 10 days of the receipt of summons of judgment, 30 days of the receipt of summons for judgment, 90 days of the receipt for judgment, 120 days of the receipt of the summons for judgment. Here the correct answer is option 1, that is 10 days for the receipt of summons for judgment. Question number 112. The period of limitation for filing an application for review is 30 days of the judgment order, 60 days of the judgment or order, 90 days of the judgment or order, 120 days of the judgment or order. Correct answer is 30 days from the judgment or order. Question number 113. The period of limitation for filing revision petition to the High Court under the Section 115 of the CPC is 30 days of the judgment or order, 60 days of the judgment or order, 90 days of the judgment or order, 180 days of the judgment or order. Correct answer is 90 days of the judgment or order. If the defendant is abroad during the period of limitation, such period is excluded from the period of limitation. Such period is included in the period of limitation. Such period is excluded from the period of limitation only if the period of stay abroad is then 30 days. None of these. Correct answer is option 1, that is such period is excluded from the period of limitation. The Maharaja of Princely States of Jammu and Kashmir, under whose reign the instrument of accession was signed on 26 October 1947 was, correct answer is Hari Singh. Question number 116. Which of the following refers to a special fund initiated by the Delhi High Court for the victims of burn related injuries? Options are Ashray, Asra, Sahara, Asha. Correct answer is Asra. Question number 117. According to the Supreme Court Number of Judges Amendment Bill 2019, the maximum number of judges of the Supreme Court of India has been increased from 30 to, correct answer is option 3, that is 33. In April 2019, Julian Assange was arrested by the London Metropolitan Police from the Embassy of Ecuador. The Indian Legal History Museum is located in, correct answer is Gandhinagar. Which state has recently passed the anti-mob lynching bill? Correct answer is Rajasthan. Which among the following countries recently allowed women to travel abroad without approval of the male guardian? Correct answer is Saudi Arabia. Question number 122. Donald Trump accused two countries exploiting the WTO's developing economies tag. Which are the two countries? Options are China and Taiwan, India and China, India and Pakistan, Pakistan and Bangladesh. Here the correct answer is option 2, that is India and China. Question number 123. Wing Commander Abhinandan Vardhaman was facilitated with which of these honors? He was associated with the Veer Chakra. Question number 124. Which of the following Chief Minister of Delhi initiated the Bhagidari project to provide the better public services by promoting civic participation? Correct answer is Sheila Dikshit. Question number 125. Tobacco companies in USA exercise the rights listed in this to prevent the display of graphic warning on cigarette packets. Which is the correct option? First Amendment, Second Amendment, Third Amendment and Fourth Amendment. Correct answer is First Amendment. Question number 126. Which of the following was the first woman to hold the office of Ministry of External Affairs in India? Correct answer is Indira Gandhi. Question number 127. Who was the first woman judge in the Supreme Court of USA? Correct answer is option 3, that is Sandra Day O'Connor. Question number 128. Which of the following has come to be associated with the 2019 Hong Kong pre-democratization protest? Correct answer is Blooded Eye Patch. Option 1 is the right answer. Question number 129. The commission that drafted Indian Penal Code 1834 was headed by, correct answer is T.B. Macaulay. Question number 130. The recently deceased Nobel Prize winning author Toni Morrison won the Pulitzer Prize for the fictional work in the year 1988. Identify the work. Correct answer is option third, that is beloved. Question number 131. Who was one of the first female judges in the British Empire and the first female judge in an Indian High Court? Option third, that is Anna Chandi. Question number 132. Who is the Indian woman sportsperson to be recommended a Padma Vibhushan? Options are Mary Kom, Kalamjeet Sandhu, P.T. Usha, Anju Bobby George. Here the correct answer is option first, that is Mary Kom. The US Secretary of State is, correct answer is option first, Mike Pompeo. Question number 134. In 2019, India imposed 200% custom duty on goods imported from which country? Options are Pakistan, China, USA, Nepal. Correct answer is Pakistan. The present UN Secretary General is, option first is the correct answer, that is Antonio Guterres. India ratified Kyoto Protocol to the UN Framework Convention of Climate Change in the year 2017. Question number 137. Which state first adopted the Panchayati Raj system in 1959? Correct answer is Rajasthan. In Nagaur district of Rajasthan, Panchayati Raj system was first initiated. The current Lok Sabha is the, correct answer is third, that is 17th Lok Sabha, elected in May 2019. Question number 139. The governor enjoys office at the pleasure of the, correct answer is President. Question number 140. The current Chief Economic Advisor to the Government of India is, correct answer is Krishnamurthy Subramaniam. Question number 141. The total number of schedules in the Indian Constitution are, correct answer is 12. There are 12 schedules in the Indian Constitution at present. Question number 142. The total number of high courts in India at present are, correct answer is 25. Question number 143. In 2019, India won a major dispute against the USA at the WTO. The subject matter dealt with, option first, renewable energy programs, option second, steel industry, auto industry, poultry industry. Correct answer is option first, renewable energy programs. The RCEP treaty negotiation concern the subject matter of, option first, nuclear non-proliferation, free trade agreement, environment treaty relating with the hazardous substances, and option 4, none of these. Correct answer is option second, that is FTA, free trade agreement. RCP stands for Regional Comprehensive Economic Partnership. It is a free trade agreement among the Asia Pacific nations of Australia, Brunei, Cambodia, China, Indonesia, Japan, South Korea, Laos, Malaysia, Myanmar, New Zealand, Philippines, Singapore, Thailand, and Vietnam. Now let us move to question number 145. Gangubai Hangal was a well-known exponent of which of the following genres of music? Correct answer is Khayal. Question number 146. Parliament's lack of power to alter the basic structure of the constitution was propounded for the first time in, correct answer is Sajjan Singh versus State of Rajasthan in a dissenting judgment. Question number 147. A suit is dismissed wrongly on the ground of being barred by the limitation. The order of dismissal would operate as res judicata and a bar on subsequent suit on the same cause of action. This statement is true, this statement is false. It would depend upon the facts and the circumstances of each case, and option for none of these. Correct answer is this statement is true. Question number 148. The Order 7 Rule 11 of CPC provides for, correct answer is rejection of plaint. Question number 149. In a suit for recovery of Rs 25 lakh, the defendant files its written statement and pleads that it does not owe any money to plaintiff, but in fact it is entitled to recover the sum of Rs 40 lakh from the plaintiff. The defendant, however, does not file a counterclaim. Can the defendant file the counterclaim at subsequent stage in the suit or file a fresh suit recovering the money of Rs 40 lakh? Options are the counterclaim and suit would be barred. Option second, only the counterclaim would be barred. Option third, the defendant can file both, either a counterclaim or a suit. And option four, the defendant's claim stands abandoned. Correct answer is option third, that is the defendant can file both, either a counterclaim or a suit. Question number 150. A files a suit for partition in the High Court of Delhi against her brother B. B relies upon a will executed by his father bequeathing the entire estate in his favor. Options are B has to necessarily file a counter claim seeking probate of the will. Option second, an issue will be framed as to the genuineness and the validity of the will which B can establish without seeking probate. Option third, B has to necessarily file a separate probate petition. Option 4, the suit for partition will be stayed until B obtains a probate. Correct answer is option second, that is an issue will be framed as to the genuineness and validity of the will which can be established without seeking probate. Question number 151. If non-commercial suit when issues both of fact and law arise and the court is of the opinion that the suit may be disposed of an issue or law only, the court can, option first, frame issues of law and facts and adjudicate the issues of law as preliminary issue. Option second, frame issues both of fact and law and decide all issues together. And option third, frame issue only on the issue or law and postpone the settlement of other issues. And option four, both first and third. Here the correct answer is option 4, that is first option and third option. Question number 152. For the purpose of amendment of pleadings under Order 6 Rule 17 CPC, the commencement of the trial takes place when the issues are framed, when the affidavits and evidence are filed, when the affidavits and evidence are tendered by the witnesses, once cross-examination begins. Here the correct answer is option third, that is when the affidavits and evidence are tendered by witnesses. Order 6 Rule 17 of CPC is related to amendment of pleadings. The court may at any stage of the proceedings allow either party to alter or amend his pleadings in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real question in controversy between the parties. Now let us move to the question number 153. X files a suit against Y, which is a partnership of 4 private individuals. X does not issue notice under section 80 CPC. The suit cannot be dismissed for non-compliance, has to be dismissed for non-compliance, can be dismissed at the discretion of the court if the circumstances require a notice. Suit plaint will be rejected. Here the correct answer is option first, that is cannot be dismissed for non-compliance. Question number 154. An ex parte decree passed by Court A was transferred to the Court B for execution, and which execution proceedings are pending in the Court B? Court A sets aside the ex parte decree and on rehearing a fresh decree was passed on the same terms. Options are, since a new decree is on the same terms as a decree which is set aside, the execution proceedings will continue. Option second, Court B can continue to execute the ex parte decree since the orders of the transfer has not been recalled. Option third, the decree holder can seek amendment to the execution proceedings. And option 4, the execution proceedings in Court B come to an end and a fresh execution petition would have to be filed of the new decree. Here the correct answer is option 4, the execution of proceedings in Court B will come to an end and a fresh execution petition would have to be filed of the new decree. In a commercial suit, the time limit of 120 days for filing of the written statement can be extended if the defendant shows adequate reasons for non-filing, can be extended at the discretion of the court, cannot be extended under any circumstances, can be extended with imposition of heavy cost. Correct answer is option third, that is cannot be extended under any circumstances. Question number 156. When the plaintiff appears and the defendant fails to file written statement despite service, the court, option first, shall pronounce judgment under Order 8 Rule 10 CPC. Option second, may either require the plaintiff to prove its case by leading evidence or pronounce judgment against the defendant depending upon the nature of the case. And option third, shall necessarily require the plaintiff prove its case by leading evidence. Option 4, direct personal appearance of the defendant. Here the correct answer is option second, that is may either require the plaintiff to prove its case by leading evidence or pronounce judgment against the defendant depending upon the nature of the case. Question number 157. When an interim injunction has been granted without any notice, the opposite party of the plaintiff fails to comply with the provision of Order 29 Rule 3 of CPC. Options are, the ex parte injunction lapses on the expiry of the time for the compliance. The ex parte injunction would necessarily be liable to be vacated. Option third, the court can extend the time for the compliance Order 39 Rule 3 CPC even after the defendant has appeared and filed written statement. And option 4, the ex parte injunction would be vacated if the non-compliance is prejudicial to the defendant. Correct answer is option 4, that is ex parte injunction would be vacated if non-compliance is prejudicial to the defendant. Question number 158. Issues are framed by court. Onus of some of issues is on the plaintiff. Of some of the issues, the onus is on the defendant. The plaintiff has to file its affidavits and evidence on all issues, file its affidavit and evidence in affirmative on issues onus whereof is on plaintiff, and evidence in negative on issues onus thereof is on defendant. Option third, file its affidavits and evidence in affirmative on the issues onus whereof is upon the plaintiff, file its affidavits and evidence in affirmative on all issues irrespective of onus. Correct answer is option third, that is file its affidavits and evidence in affirmative on the issues onus whereof is upon the plaintiff. Question number 159. X leases Y a property for 10 years from 2000 to 2010 where the rent is payable on the 10th of every month. Y does not pay any rent from the inception of the lease. X sues in 2011 for the arrears of rent from 2005 to 2010 only. Option first, X can thereafter file a fresh suit for the arrears of rent for the period of 2000 to 2004. Option second, X can amend the plaint to include the recovery of rent from 2000 to 2004. And option third, X claim for arrears of rent would be restricted for the period of 3 years prior to the institution of the suit. And option 4, X having not claimed rent from 2000 to 2004 is barred from claiming the rent for subsequent period. Here the correct answer is option third, that is X claim for arrears of rent would be restricted for the period of 3 years prior to the institution of the suit. Question number 160. In a suit under Order 30 CPC, the court grants the defendant conditional leave to defend subject to the defendant securing the suit amount by way of bank guarantee. The defendant fails to furnish the bank guarantee in the prescribed period. The court shall permit the defendant to file its written statement, convert the suit into ordinary suit, decree the suit against defendant, direct the plaintiff to lead evidence. Here correct answer is option third, that is decree the suit against the defendant. Question number 161. A supplies goods from Delhi to B at Mumbai under a contract which provides court in Mumbai would have jurisdiction to deal with the disputes arising out of this agreement. A sues B in a court of Delhi for the outstanding balance. Options are: the court could not admit the plaint owing to the jurisdiction clause in the contract. The suit would be admitted and only B raises an objection to the jurisdiction at Delhi would the court determine the same. Option third, B can prefer an appeal against the order of admission of the suit in the court at Delhi. And option 4, B can approach the Delhi High Court for transfer under section 24 CPC. Here correct answer is option second, that is the suit would be admitted and only if B raises an objection to the jurisdiction at Delhi would the court determine the same. Question number 162. A resident of Delhi files a suit at Delhi for infringement of trademark by B, a resident of Mumbai, for using the mark at Mumbai. Option R, the court at Delhi has jurisdiction. The court at Delhi has no jurisdiction because B is a resident of Mumbai and cause of action has arisen in Mumbai. Option third, the court at Delhi has jurisdiction with leave of court. And option 4, the court at Delhi has jurisdiction only if A does not have an office in Mumbai. Here the correct answer is option 4, that is the court at Delhi has jurisdiction only if A does not have an office in Mumbai. Question number 163. A compromise decree operates as res judicata between the parties to the compromise, does not operate as res judicata, 1 or 2 depending upon the facts and circumstances of each case, 1 or 2 depending on the discretion of the court. Here the correct answer is option first, that is operates as res judicata between the parties to compromise. Question number 164. A decree for permanent injunction restraining the defendant from interfering with the possession of the plaintiff, finding the possession of the plaintiff to be settled, would operate as res judicata in a suit for the partition filed by the defendant for the same property. Correct answer is option first, that is no. Question number 165. On receipt of an application for execution of a decree, if the requirement of Order 21 Rule 11 to 14 have not been complied with and the defects are not remedied, then court shall reject the application for execution, allow process of the application for execution, 1 or 2 depend upon the facts and circumstances of each case, none of these. Correct answer is option second, that is allow the process of application for execution. Question number 166. A holds a decree against B for rupees 5,000. B holds a decree against A for rupees 3,000. Both A and B apply for execution of decree to a court which has jurisdiction to execute both decrees. The court may allow execution of A's decree of rupees 2,000. Simultaneously proceed with the execution of both decrees. B shall proceed separately with his decree, none of the above. Correct answer is option first, that is allow the execution of A's decree of rupees 2,000. Question number 167. The period of limitation of an application to restore a suit dismissed from the default of appearances: 30 days from the date of dismissal, 60 days from the date of dismissal, 90 days from the date of dismissal, 120 days from the date of dismissal. Correct answer is option first, that is 30 days from the date of dismissal. Question number 168. Where the suit is dismissed for non-appearance by the plaintiff and the defendant is not yet served, or after service of the defendant both parties do not appear, the plaintiff may bring a fresh suit for the same cause, apply for an order to set aside the dismiss, file and appeal, either 1 or 2. Correct answer is option 4, that is either 1 or 2. Bring a fresh suit for the same cause, apply for an order to set aside the dismiss. Question number 169. A granted an injunction restraining B from use of trademark. A alleged that B had willfully disobeyed the injunction order. B pleaded that he had no knowledge of injunction order. Evidence was non-conclusive. The court shall order none of these because the options are property of B attached, B to be determined in civil prison, and B to be compensate A by damages. None of the above is the correct answer, that is option 4 is the right answer. Question number 170. A decree shall not operate as res judicata when judgment is passed by a court which does not have subject jurisdiction. Judgment is obtained by fraud if collusion is proved between parties. All these. Correct answer is option 4, that is all of these. Question number 171. A filed a suit against 3 defendants. Defendant number 1 alleged that there was no cause of action against him under Order 7 Rule 11D of CPC. The plaint is to be rejected in whole, rejected in part if the cause of action is not joint and several. Proceed with against all defendants. Option 4, none of these. Correct answer is option 2, that is rejected in part if the cause of action is not joint and several. Question number 172. In a civil suit coming up for admission, if the court does not have subject jurisdiction to grant relief in the suit, the court cannot grant interim relief under Order 39 CPC, can still grant interim relief under Order 39 CPC, has to nevertheless issue summons of the suit, has to frame a question of law and refer to the High Court. Correct answer is option 1, that is cannot grant interim relief under Order 39 CPC. Order 39 CPC is related to the temporary injunctions. Question number 173. In a suit for permanent injunction against a defendant company, the plaintiff sought an interim injunction restraining the defendant from prosecuting the suit in a foreign court. Options are: temporary injunctions can be granted from restraining the foreign court from proceeding with the suit. A temporary injunction restraining from the foreign court can be granted if there is a prior pending suit in India, irrespective of where the defendant resides or carries on business. Option 3, a temporary injunction restraining the defendant from prosecuting the foreign suit can be granted if the defendant is amenable to the jurisdiction of the court. And option 4, all of these. Correct answer is option 3, that is temporary injunction restraining the defendant from prosecuting the foreign suit can be granted if the defendant is amenable to the jurisdiction of the court. Question number 174. An order passed under Order 39 Rule 1 CPC can be challenged by filing an appeal. Correct answer is first, that is an appeal. Question number 175. Under Order 9 CPC, where a suit is wholly or partly dismissed under Rule 8, the plaintiff shall be precluded from bringing a fresh suit in respect of the same cause of action. Plaintiff may apply for an order to set or dismissal aside. Plaintiff may bring a fresh suit in respect of the same cause of action. Option 4, either 1 or 2. Either 1 or 2 is the correct answer, and option 4 is the correct answer. Question number 176. During the pendency of an appeal by the 4 defendants in the suit, one of the appellant defendant dies and no steps for substitution of his legal representative are taken, and the appeal insofar as it relates to the said appellant abates. The 5 respondents plaintiff apply for dismissal of the entire appeal as abated. Answer whether the entire appeal abates and has to be dismissed. The entire appeal abates only if the cause of action against all of the defendants was won and allowing the appeal of the other defendants would lead to inconsistent decrees. The appeal should only be of the deceased appellant abates, and as far as the other defendant appellants are concerned has to continue. The proceedings in the appeal have to be stayed, and the second appeal is required to be filed for the determination of this question. Correct answer is option 2, that is the entire appeal abates only if the cause of action against all the defendants was won and allowing the appeal of the other defendants would lead to inconsistent decrees. Question number 177. The court at the first hearing of the suit can only frame issues, may permit cross-examination of the either party of the other, to elucidate the matters and the controversy in the suit, may examine either of the parties, and option 4, none of these. Correct answer is option 3, that is to elucidate the matters in controversy in the suit, may examine either the parties. Question number 178. Failure of the judgment debtor to file affidavit of assets under Order 21 Rule 41 Clause 2 of the Code of Civil Procedure can result in civil imprisonment up to 3 months for the judgment debtor, civil imprisonment up to 6 months for the judgment debtor, civil imprisonment up to 9 months for the judgment debtor. Option 4, imposition of fine on the judgment debtor of the deceitful amount. Correct answer is option 1, that is civil imprisonment up to 3 months for the judgment debtor. Question number 179. Parties A and B have agreed on the seat of arbitration. The same can be changed by the arbitral tribunal unilaterally, cannot be changed at all, can be changed by the agreement of parties, cannot be changed by the parties unless arbitral tribunal permits. Correct answer is option 3, that is can be changed by the agreement of parties. Question number 180. An application to set aside the arbitral award under the Arbitration and Conciliation Act 1996 may be made within a time period of the following number of days that have elapsed from the date on which the party making the application had received the arbitral award. Options are 1 month, 2 months, 3 months and 45 days. Correct answer is option 3, that is 3 months. Question number 181. An arbitration agreement entered on 1st August 2019 provides for the arbitration to be in accordance with the Arbitration Act 1940. The arbitration would be governed by the provisions of the Arbitration and Conciliation Act 1996. The arbitration would be governed by the provisions of Arbitration Act 1940. The arbitration clause is void And option 4, the arbitration award would be governed by the provisions of the Arbitration Act 1940 as well as the Arbitration Conciliation Act 1996. Here the correct answer is option first, that is the arbitration would be governed by the provisions of the Arbitration Conciliation Act 1996. Question number 182. The arbitration agreement expressly asks the jurisdiction of the consumer forums. In such a case, only arbitral tribunal will have the jurisdiction, only consumer forum will have the jurisdiction, as it's a special act. Both for a will have jurisdiction to adjudicate the disputes. The clause would be void, only a civil suit would lie. Correct answer is option third, that is both will have jurisdiction to adjudicate the disputes. Question number 183. An arbitration clause contained in a deficiently stamped and compulsorily registrable document is enforceable even without deficient stamp duty being paid, is enforceable only if the deficient stamp duty along with the penalty, if any, is paid, is invalid, is enforceable only if the deficient stamp duty along with the penalty, if any, is paid and the document is registered. Here the correct answer is option second, that is enforceable only if the deficient stamp duty along with the penalty, if any, is paid. Question number 184. A non-signatory to the arbitration agreement can be made party to the arbitration proceedings under some circumstances or grounds. Question number 185. In a pending arbitration case, the arbitral tribunal passed an order of interim injunction under section 17 of the Arbitration Conciliation Act 1996 restraining in an encashment of a bank guarantee. The agreed party has the following remedies: file a review before the arbitrator, file an appeal under section 37 of the Arbitration Conciliation Act 1996, file a civil suit challenging the interim order, and option 4, none of these. Correct answer is option second, that is file an appeal under section 37 of the Arbitration Conciliation Act. Section 37 talks about the appealable order. Question number 186. Disputes between A and B are referred to the arbitration under the Arbitration Conciliation Act 1996. The final award is rendered 1st June 2019 in favor of B. During the ensuing summer vacations of the court, an urgent situation arises in which B wishes to seek interim relief. B can approach the arbitral tribunal under the section 17 of the Arbitration Conciliation Act 1996 for interim orders. Option second, approach the court of competent jurisdiction under section 9 of the Arbitration Conciliation Act 1996 for interim orders. Not obtain any interim orders as a final award has been passed. Approach the Supreme Court for interim order. Correct answer is option second, that is approach the court of competent jurisdiction under section 9 of the Arbitration Conciliation Act 1996 for interim orders. Question number 187. Under section 8 of the Arbitration Conciliation Act 1996, the reference parties to the arbitration is mandatory. Correct answer is mandatory. Question number 188. A nomination of an arbitrator is made by a person who is himself ineligible act as an arbitrator under section 12 clause 5 read with 7 schedule to the Arbitration Conciliation 1996. In such a case, the nominee cannot act as an arbitrator. Such a nomination would be void ab initio, both first and second. Such nomination is valid. Correct answer is option third, that is both first and second. The nominee cannot act as an arbitrator. Such a nomination would be void ab initio. Question number 189. A petition for execution of an arbitral award for the recovery of money by attachment and sale of immovable property of the judgment debtor at Delhi is filed at New Delhi. Though the objections against the arbitral award were dismissed by the court at Ludhiana and without seeking transfer from the court, would the execution petition is maintainable? Correct answer is yes, it is maintainable. Question number 190. The parties to the arbitration agreement are resident of Lucknow and Kolkata. The contract was performed at Varanasi. The parties agreed that arbitration proceedings will be conducted at New Delhi and were held at New Delhi. Where will the petition under section 34 of the Arbitration Conciliation Act 1996 be filed? Options are Delhi, Lucknow, Varanasi, Kolkata. Correct answer is Delhi. An application under section 8 of the Arbitration Conciliation Act 1996 is filed by the defendant after the defendant has filed his written statement on merits and after framing of issues in which no issue qua arbitrarily is framed. The court must issue notice of the application to plaintiff and call for reply, allow the application if there is an arbitration agreement, dismiss the same as not maintainable, frame an issue on the same to be determined at trial. Correct answer is option third, that is dismiss the same as not maintainable. Question number 192. A petition under section 34 of the Arbitration Conciliation Act 1996 is filed on the 41st day after the expiry of limitation prescribed section 34 clause 3 of the said act, along with an application for condonation of delay is filing thereof. The petitioner makes out sufficient ground for the condoning delay. The court must condone delay and issue notice of petition under section 34 of the Arbitration Conciliation Act 1996 to respondent. Issue notice to respondent only by the application seeking continuation of delay, dismiss the application for the continuation of delay as well as a petition under section 34 of the Arbitration Conciliation Act 1996 on the ground of limitation, issue notice of the application seeking continuation of delay as well as of the petition under section 34 of the Arbitration Conciliation Act. Correct answer is option third, that is dismiss the application for continuation of delay as well as the petition under section 34 of the Arbitration Conciliation Act 1996 on the ground of limitation. Question number 193. A petition under section 48 of the Arbitration Conciliation Act 1996 against foreign award must be filed before district court having territorial and pecuniary jurisdiction, high court, supreme court, all these. Correct answer is high court. Question number 194. The petitioner in a petition under section 34 of the Arbitration Conciliation Act 1996 shows that another method of calculating damages was preferable than one adopted by the arbitrator. The court must set aside the award, remand the award to the arbitrator of reconsideration, dismiss the petition, award damages on the basis of the other method. Correct answer is option third, that is dismiss the petition. Question number 195. A institutes a suit against B with respect to the disputes arising out of an agreement entered into with B. The said agreements provide for arbitration of all disputes, including the disputes subject matter of suit. The court before which the suit comes up for admission will dismiss the suit, will refer the disputes and parties of arbitration, will admit the suit if otherwise maintainable in law, will direct the plaintiff to approach the High Court under section 11 of the Arbitration Conciliation Act 1996 for the appointment of arbitrator. Correct answer is option third, that is will admit the suit if otherwise maintainable in law. Question number 196. A has let out of his property at Delhi to B at rent of rupees 3000 per month on the terms and conditions contained in a registered lease deed. The lease deed provides for arbitration of all disputes between the parties. B fails to vacate the property in spite of expiry of period of lease for 2 years. A initiates arbitral proceedings under the Arbitration Conciliation Act 1996 in accordance with an arbitration clause in the lease deed seeking ejectment of B from the property. Options are: the arbitral proceedings are maintainable, the arbitral proceedings are not maintainable, the arbitral proceedings are maintainable only if B does not object the same, the arbitral proceedings are maintainable with the express consent of B. Correct answer is option second, that is arbitral proceedings are not maintainable. Question number 197. A files a suit against B for recovery of money due under the agreement, term whereof has since expired by efflux of time. B files an application under section 8 of the Arbitration Conciliation Act contending that the agreement contains an arbitration clause. The court would then dismiss the application and continue with the suit as the agreement including the arbitration clause thereof has expired by efflux of time. Option second, refer the parties to the arbitration, and option third, refer the parties to arbitration only if the plaintiff agrees to such arbitration. Option 4, refer the parties to the High Court under section 11 of the Arbitration Conciliation Act 1996 for determination if the arbitrator needs to be appointed. Correct answer is option second, that is the refer the parties to the arbitration. Question number 198. The bar under section 42 of the Arbitration Conciliation Act 1996 is not applicable to application under section 8 of the said act, application under section 11 of the said act, application under act filed in a court that has no jurisdiction subject matter, and option 4 all of these. Correct answer is option 4, that is all of these. Question number 199. On the very filing of a petition under section 34 of the Arbitration Conciliation Act 1996 for setting aside of an arbitral award in an arbitral proceedings which has commenced after 23/10/2015, the arbitral award becomes an inexecutable. The award is eclipsed. Option third, the arbitral award remains executable unless execution thereof is stayed by the court before which such petition is filed. Option 4, arbitral award is executable only with the permission of the court before which the petition under section 34 of the Arbitration Conciliation Act 1996 is filed. Correct answer is option 3rd, that is arbitral award remains executable unless execution thereof is stayed by the court before which such statement is filed. Question number 200. An arbitration agreement provides for the arbitration under the Arbitration Conciliation Act 1996 by two arbitrators, one to be appointed by each party. Options are: the arbitration agreement is void, the arbitration agreement is of arbitration by three arbitrators with the third arbitrator to be appointed by the court, the arbitration agreement is of the arbitrator by one arbitrator either to be appointed jointly by the two parties, and if not the same. Option 4, the arbitration agreement will be enforced as it is. Correct answer is option 3rd, that is the arbitration agreement is of the arbitration by one arbitrator either to be appointed jointly by the two parties and if not by the court. Here we will end this paper of Delhi Judicial Services 2019. Please like, share and subscribe to us, and also join our Telegram channel, the link of which is given under the description. Thank you so much. Thank you for watching.